and welcome to the Part 2 webinar by Ayrton Burles on the new Local Planning Appeal Tribunal. I'm Leo Longo, and with me is Patrick Harrington, my colleague and partner, and we will again be presenting to you an update on the materials we have previously provided. We welcome your questions and comments. Please feel free to type in any during the session. They will be run up to the broadcast room, and we'll try to leave room at the end of the session to answer some of those questions. As you can see on the next slide, that just by way of background, Bill 139 has now been enacted, and it's entitled the Building Better Communities and Conserving Watersheds Act 2017. That's a name that you can promptly forget. You will never be citing this legislation by that name ever again. What's important to note is that legislation provided a bare bones act and attached 5 schedules to it, the most significant of which for this webinar is the fact that there is a new Local Planning Appeal Tribunal Act and significant amendments to the Planning Act. And it will be those pieces of legislation which will be cited throughout this webinar and will be cited in your practice as you move forward. The Act received royal assent in December of last year and has been proclaimed as of today. When I turned on my computer on this morning and clicked on my normal link to the Ontario Municipal Board, I was directed to a page on Alto that said this site no longer exists, and the new LPAT link is now live on the Alto website. So what has ended concerning Bill 139? Well, there's one significant thing that has ended, and that's the Ontario Municipal Board Act has been repealed as of today. That act took effect in 1932, and as we've indicated, served, we believe, the province well over the last 86 years. May it rest in peace. It has, as you know, been replaced by the new Local Planning Appeal Tribunal Act. But it's important to note that while the OMB Act has now been repealed, the OMB itself has been continued, but under the new name. So you can see that the board was originally named the Ontario Railway and Municipal Board in 1906, the OMB in 1932, and now LPAT as of today. The board itself, because it's being continued, remains the oldest administrative body within the province dispensing administrative justice. We note that it is unfortunate that the legislation does not include the name Ontario in the Act, and this has caused confusion already amongst citizens and clients, wondering, well, does that mean it's no longer run by the province? And secondly, its name is quite confusing to local appeal bodies, which can be set up under the Planning Act and which has been set up in Toronto under the City of Toronto Act. While it was suggested that the name be changed during committee proceedings, that was not pursued. So what has changed? Significantly, one's appeal rights to get to the board, now the tribunal, have significantly been altered and reduced. As well, there are new appeal tests that exist for OPs, OPAs, zoning bylaws, and zoning bylaw amendments. And the appeal process itself has changed, as has the fact that no live witnesses or cross-examination will be permitted during the first appeal of the appeal process that has now been established. All of these matters were covered off in our first webinar and PowerPoint, which are archived on our firm's website and are available for you to read. The purpose of today is not to repeat any of that webinar, but update you as to where we are as of today's date. So I'll turn it over to Patrick to introduce an overview of what has changed.
So as Leo said, the last presentation looked at in depth the changes to the Planning Act, changes to appeal rights and appeal pathways up to the new LPAT. And what we noted in our last presentation were there were a number of things that we just didn't know yet at that time, what the rules were going to look like, confirmation of what the transition protocols were going to be. As of now, April 3rd, the in-force date for the legislation, we now have that clarity in terms of what the rules of the LPAT are going to be and what the transition protocols are going to be. And so the purpose of this presentation is to try to present those nuts and bolts to you. As you'll see as we go through some of the transition regulations, a lot of what needed to happen to preserve appeal rights better have already happened if you're dealing with a transition matter. The second part of the presentation will go through the new rules and try to review what's new under Part 1 of the new LPAT's new rules, and in particular paying close attention to Part 2, which is the section of the rules that will set out the appeal routes for these first appeals and second appeals that are now created under the amendments to the Planning Act. And then we'll finish off with some summary thoughts on how this all affects applicants, municipal authorities, and members of the public before we get to some of the questions that we hope you'll be able to send to us. We did review in our last presentation some of the transition protocols that were proposed at that time. This slide is meant to be kind of a summary of some of that information. These are the matters in which you will not be subject to the Bill 139 amendments to the Planning Act. This is under OREG 174-16. So these are matters that are strictly with respect to the Planning Act itself. Appeals of non-decision on private applications where the complete application was filed prior to the royal assent date, which was December 12, 2017, and the appeal was filed prior to today's date. So two parts, that you had a complete application prior to December 12th, and in light of the decisions coming out of the Divisional Court on the Oakville matter, we know that the complete application is when the application materials were filed as opposed to when it was deemed complete. And then the appeal had to have been filed before today's date. Moving down the slide, appeals of municipal decisions on privately or publicly initiated amendments where the decision was rendered prior to December 12th. Those would stay at the OMB and be subject to the old act, as I'll now call it. Appeals of approval authority non-decisions where the lower decision was rendered prior to royal assent. Interim control bylaws passed prior to today. Ministers' decisions rendered prior to today. And requests to refer minister zoning orders where the request was filed prior to today. What is going to be subject to the new regime? Basically any scenario that doesn't match what was set out in the prior slide, and all appeals that are going to be filed today and after today, regardless of when the matter was commenced. The final point on this slide has to do with the new 2-year freeze on secondary plans, and as we reviewed in our last presentation, secondary plan has a very wide definition, but the transition to that freeze, which is a freeze on when you can apply to amend a secondary plan, it applies to all or any part of a secondary plan that comes into effect today and after today, and then it applies to all secondary plans after April 3rd, 2020. So if you have a new secondary plan that takes effect after today, you will need council's permission before you can file an application to amend that secondary plan. There is one interesting kind of hole in the donut, so to speak, which is the scenario where you are appealing a decision that was rendered after royal assent and your appeal was filed prior to April 3rd. What is intended to happen to your appeal in that circumstance? In this case, and it's spelled out in the regulations, Staff at LPAT will send you a notice indicating that while they've received your appeal, they are requesting that you or directing you to file a new notice of appeal. And that new notice of appeal must explain how your appeal satisfies the new or the joint tests, or that the matter being appealed does not satisfy the new or the joint tests. And we reviewed what those tests were in our last webinar. If you are going to proceed to file your new notice of appeal, it must be submitted within 20 days of receiving the LPAT's notice or direction. If you do not proceed to file your new notice, your appeal is deemed to have been dismissed. The fortunate part is that your clients do not have to pay the appeal fee again, but they are going to have to make your lawyers do a little extra work.
Patrick, I went online this morning just to see what the new LPAT website looked like, and while they do have an appeal guide that is posted online, I think it's 31 or 41 pages long, explaining how an appeal is to be filed and what the process is. To my knowledge, I could not find an appeal form anywhere on the website. So they haven't gone live with those forms. So anybody wishing to appeal today or tomorrow may find that they're frustrated in not having the appropriate form. And I don't think using a former OMB A1 form would be an appropriate thing to use. So that's something that our listeners will have to be checking for themselves.
The next regulation deals with the LPAT Act itself. As Leo highlighted originally, it is an act that is replacing the OMB Act, and so it needs its own transition protocol, and that's provided by OREG 101.18. The transition is essentially mirroring the Planning Act transition protocols, which I had mentioned to you earlier. The default position is that if you've got an appeal before April 3rd, you'll be governed by the old OMB Act and proceed in front of the old OMB, which the board is now referring to as legacy appeals. And if you are appealing after today or after today, you will be appealing to the new tribunal and be subject to the tribunal's new act and new rules. There are certain exceptions. Appeals of municipal decisions on official plans, official plan amendments, zoning bylaws, and zoning bylaw amendments where the decision was issued after royal assent is intended to go to the new tribunal. And appeals of official plan amendments and zoning bylaw amendments that were received after December 12th are intended to go to, I believe those are applications, and appeals received after that date go to the new LPAT Act. The commencement dates are tied to the statutory notices, so what you're concerned about is when the particular municipal authority has issued their notice of decision, and then you fit that into the regulation to figure out what the result is.
So there's no confusion with our listeners. While you will be under the old OMB Act and its provisions, the body deciding your appeal is the new tribunal, just to be absolutely clear. It's not that they're wearing an OMB hat on some occasions and an LPAT hat on another. It's always LPAT that will be making the decisions, but legacy appeals will be disposed of under the former act.
And that leads to a number of the questions that we were receiving before we began today, is how are we going to be, or how is the tribunal going to be matching up legacy appeals and new appeals? Obviously, they're governed by two different acts and two different sets of rules. And I don't believe it is the tribunal's intention to try to consolidate them so they're heard under one or the other. I believe the best the tribunal is going to be able to do in those circumstances is try to schedule your matters in a back-to-back fashion, where one matter is going to be heard by the tribunal under the OMB Act and OMB rules, and your next matter, which is subject to the LPAT, is going to be subject to the LPAT rules and LPAT tests and the amendments to the Planning Act. I believe because you're dealing with the same tribunal, and I think Leo tried to make that clear for those in the public who are still confused about this, the LPAT is the OMB. That is, all the members of the OMB are continued as members of the tribunal. So you may be able to schedule your OMB matter and your LPAT matter in a back-to-back fashion to be heard by the same member. And I believe the tribunal will also try to ensure that the higher level planning instrument is the one that gets heard and determined first. So if you have an OPA and a ZBA, you are probably going to get your OPA scheduled in advance of the resolution of your ZBA. The interesting question will be how these timelines come into effect, because LPAT appeals and LPAT matters are now subject to Reg 10218, which brings along timelines in which the LPAT must dispose of Planning Act appeals. These timelines begin running when the LPAT receives and validates the appeal, and there's a process for validation provided under the new LPAT rules. And the regulation itself, which is not something the LPAT can change on its own, applies to appeals of OPs, OPAs, zoning bylaws, and zoning bylaw amendments. First appeals, which are those kind of almost like a motion for leave type appeal, where you go and you try to convince the tribunal that you satisfy either the new or the joint test. The timeline between the LPAT receiving your appeal and the disposition of that first appeal is intended to be completed within 10 months. Then, if your matter goes back down to the municipal authority and it comes back up to the LPAT because the municipal authority didn't do anything with it or did something with it and it resulted in a further appeal, that second appeal, according to the reg, is to be disposed of within 6 months of the LPAT receiving a valid second appeal. Moving down the slide, appeals of non-decisions by approval authority, so those are your regions and your counties, on an official plan or an approval authority on a draft plan of subdivision is meant to be resolved within 12 months of the LPAT receiving the appeal. And then all other appeals, which would include your minor variances, your consent to severs, all of your site plan referrals, those are intended to be resolved within 6 months. These are not timelines that are new to the tribunal or the board. These are timelines that the board strive to achieve on their own. But this is the first time that the province has taken it upon themselves to impose these as deadlines for resolving these appeals. And the interesting question will come when you've got an existing Ontario Municipal Board appeal, a legacy appeal that's not subject to these timelines, and whether or not those hearings, if they're scheduled in the calendar, will ultimately get bumped so that the new tribunal can complete its timeline as prescribed by this regulation. I think the tribunal has indicated that where appropriate or where needed, that will in fact happen. The last bullet on the slide talks about time stoppages, so to speak, if a postponement is granted, and postponement is a term that's used in the new LPAT rules. And the postponements can be granted to permit a mediation or because a proposed postponement is deemed necessary to secure a fair and just determination of the appeal. So postponements work to stop the clock on these 10, 6, or 12 months timelines to allow another process like mediation to run its course. And then there will be a notice of recommencement when that postponement is over. The other interesting thing that OREG 10218 does is it imposes time limits on oral submissions. And this applies to first appeals of official plans and their amendments, zoning bylaws and their amendments, and draft plan of subdivision non-decisions. The time limits only apply to the first appeals. They do not apply to the second appeals. And these time limits do not apply to any other types of appeals, for example, your minor variance appeals and your site plans and your consent to severs. A party under this reg is going to be limited to an oral submission of no longer than 75 minutes, and a participant is going to be limited to an oral submission of longer than 25 minutes. And I'm going to pause to indicate here that there is no guarantee that just because you filed an appeal, you are going to get an oral submission. The regs and the rules in the new LPAT Act allow the tribunal to dispose of matters in writing, to dispose of matters through electronic hearings. Oral submissions and the need for oral submissions are the determination of the tribunal. And whether and how and when you're going to get a chance to give an oral submission is going to be at the tribunal's discretion. When will the tribunal determine whether or not you're going to get a chance to make an oral deputation before it? That's likely to be addressed in what's called the case management conference, which we'll get into when we get to the rules. But the other interesting question is, in multi-party and multi-participant proceedings, it's not clear whether or not every party is going to get their own 75 minutes or whether parties of like interest are going to be made to split up the 75 minutes, or whether every participant who attends is going to get their own 25 minutes, or whether or not the tribunal will determine that the participants, let's say there's 5 participants, will they each get 5 minutes, or will they each get 25 minutes? And as indicated in the bottom of the slide, we think that's going to be one of the prime determinations made by tribunal members when matters come before them for case management conferences.
Certainly from a legal perspective, these changes are going to be very challenging to our advocacy skills and our ability to concisely state to the OMB in 75 minutes why the test, the new test under the LPAT Act has indeed been met, in that a municipal decision is either inconsistent with the PPS or fails to conform to provincial or upper tier planning. To limit yourself to an oral submission without cross-examination, without witnesses, from a written record will truly be a new challenge that lawyers appearing before the tribunal will have to face, and those that succeed will no doubt do well in retaining future clients and working through these things. But this is a real challenge that we'll all be facing. It's also, we'll be curious to see to what extent the board member allows the time limit to be extended under the guise that the board member requires more time for himself or herself to understand the submissions that are being made. So it'll be quite curious to see if this time limit is going to be exempted more than followed. But we'll just have to see as we start developing a practice on these first appeals.
The last portion dealing with OREG 102 deals with the restriction on cross-examination, which Leo had mentioned earlier. The reference in the Act is subparagraph 42(3)(b) of the new LPAT Act. It states that no party or person may adduce evidence, and in discussions with my colleagues, it's generally acknowledged that the word adduce is very, very broad and can capture a number of different ways evidence can come before a tribunal. So no party may adduce evidence or call or examine witnesses at a first appeal concerning an OP, OPA, ZB, ZBA, or non-decision on a draft plan of subdivision. The regulation adds that no party or person may call or examine witnesses prior to the hearing of such an appeal. So when the initial LPAT Act came out, I know from my discussions with colleagues, it was generally believed that we would all be going off to the court reporter's office to do our cross-examinations, generating a transcript, and then bringing that transcript into the hearing room to show how the evidence of a particular witness was tested, and how their credibility may have been challenged. This reg effectively takes that ability away. It prevents these examinations or cross-examinations occurring outside of the tribunal room. And so now the LPAT itself, under Section 33 sub 2, is really the only person or the only entity that can cross-examine a witness. And there's really no indication of when or where that cross-examination might occur. As indicated later in slides dealing with the rules, there is an opportunity for tribunal members to cross-examine witnesses as early as case management conferences or pre-hearing conferences. And there's no obligation on any tribunal member to carry out a cross-examination. So the last point on this slide that we flag is whether or not this raises an issue of fairness or natural justice. Can the tribunal rely on opinions provided in reports without such opinions being tested by examination or cross-examination? That is the benefit of the kind of trial format that the board currently operates under. Take that away, and you've got lawyers arguing whether or not a particular report is faulty or is based on inappropriate assumptions, or whether the witness should be believed to be credible or not. The LPAT is certainly free to conduct their own examination to determine whether or not those are real issues, but where they haven't, can you really assert that the evidence has been appropriately tested?
So now that we've reviewed the new regulation respecting transition and timelines, we'd like to now turn to the actual rules of practice and procedure that LPAT has published. And we'll have a slide at the end of the presentation with a link to the new rules. For those of you who have been watching this, LPAT produced draft rules at the end of February for consultation with the public. As of last Thursday, they published the final set of rules that are dated to be effective April 3rd. It is those later rules that we have included in the slides that follow. So if you have the old draft rules in February, throw them out. They have changed, and get yourself the current final version.
So the new rules are divided into three parts, and what you'll often start hearing lawyers and consultants refer to as Part 1 appeals and Part 2 appeals. Part 1 applies to all appeals before the tribunal, and Part 2 is only going to apply to those new first appeals, which, as we indicated previously, apply to OPAs, zoning bylaws, and appeals of non-decisions on draft plans of subdivision. And there's a slide to confirm which sections of the Act that apply to. So those are the only situations where you're going to be delving into Part 2. And then Part 3 provides some extra directions under the Expropriations Act, but due to our time constraints today, we're not going to be able to dig into that in any great detail. What's new in Part 1, as I flagged for you earlier, there is a new concept of something called a notice of commencement, a notice of postponement, and a notice of resumption. And this deals with those new regulatory timelines that the LPAT must render its decision within. A notice of commencement is a confirmation that the tribunal has received your appeal, that it is a valid appeal, and that the timeline has now officially begun to get your matter heard and determined. A notice of postponement is a notice that will get issued to effectively stop the clock on that regulatory timeline. And as we note in the sub-bullet, it's not the same as an adjournment. You can have an adjournment granted, but it doesn't necessarily stop the regulatory clock. If you want that clock stopped, you are going to have to ask the LPAT to issue a notice of postponement so that you and the LPAT doesn't run out of time to have your matter heard and determined. And then a notice of resumption is the way the board will officially recommence the timeline clock. Also in Part 1, there is an emphasis on electronic means of exchanging documents. It's not that different from the current rules, as the board had been good in updating its rules to reflect current practices of exchanging via email. But there is some direction in the rules about when matters must be exchanged by paper and when matters must be exchanged in electronic form. Rule 501 indicates that when proceedings are initiated by filing an application or appeal directly with the LPAT, the material, this includes the appeal material, must be provided in both written and electronic form. There's Rule 701, which talks about whenever possible, an electronic copy of the document must also be filed with the tribunal identically numbered as the paper document, so it's effectively a scanned copy of a document that's being filed in paper. And then the rules regarding when and how documents are served. You can serve them electronically. They're deemed to be sent on the day you sent the email unless you sent it after 4:30, in which case it's deemed to be sent on the next business day. If you have confirmation that you sent the email, that is proof of service, and that a hard copy need not also be sent unless it is requested, and if it is requested, then sending it by snail mail is appropriate. Again, these are practice directions that I think a lot of us are already abiding by in terms of service of documents, exchange of document books, exchange of affidavits. We're often serving them via email, via certain documentary programs that allow you to download them, and then we often follow it up with a hard copy sent via regular mail to the tribunal.
What will be very important in a situation where you're in first appeals dealing with OPs, zoning, and non-decisions of subdivisions is the content of the municipal record, because in essence this is the document that the board will rely upon and lawyers will rely upon for making their oral 75-minute oral submission. So it's very important that any applicant ensure that the record contains all the necessary reports by various consultants that substantiate and support the approval of your application, because you will not be allowed to augment that material to any great extent. We will discuss certain things that can be filed. So on this slide, you actually see what the content of a municipal record will be, and we understand that LPAT is working on a checklist that municipalities will be able to have access to assist them in putting together the materials. But as you can see, it's generally what we would normally think of as the public record: the application form, all written submissions that have been filed, all the documents and reports that have been filed or prepared. And that means not just those of the applicant, but those of any other person who's participated and filed planning reports or other reports to support their position in the matter. We also see that an affidavit of an employee will be required to provide a summary of the oral submissions that were received. What I find very interesting is now video and audio records, where available, are to be submitted to the OMB. That will be, I think, quite an interesting nuance now to board submissions, where you could maybe play a part of a council meeting in front of the board so the board gets the flavor of what has occurred. And then simply a list of persons who did provide submissions and where in the oral recording those individuals can be heard. Patrick, you want to take the notice periods too?
Notice periods we're providing with a slide, and it wasn't my intention to just read them out, but it's a reference for the amount of notice that you're going to be given for hearings before the LPAT. So these are the notices that are, and who gets to serve them: appeals of OPs and OPAs and privately initiated OPs. For the most part, it's 60 days for all the appeals of all of these instruments. The exception being holding bylaws and interim control bylaws and draft plan conditions are 30 days, and that the notice of first pre-hearing conference, I think most of us are aware that usually that notice has to be served 35 days in advance. That has now been reduced to 30 days in advance. With respect to party status, the tribunal can add a person as a party when that person satisfies the legislative tests, and there remains tests within the Planning Act for you to satisfy the tribunal that you should be added to a party. And the rules also indicate that their presence is necessary to enable the tribunal to adjudicate effectively and completely on the issues in the proceedings. The interesting new thing about the rules is that it attempts now to enshrine the concept of sheltering. And those of us who practice in front of the OMB are very familiar with the concept of sheltering, which is that if you are not an appellant and you wish to be added as a party, you must identify an appeal or an appellant under which you are sheltering your party status. And so long as that appellant remains part of the proceeding, you can remain a party. But if that appeal disappears, you cannot maintain an appeal on your own, and the board's not going to create an appeal for you. And so Rule 803 enshrines that, but it also goes a little bit further insofar as it also indicates that the added party who is sheltering may not raise or introduce new issues in the proceeding. And that seems to be a change in the way the board has dealt with sheltered parties in the past. If you are sheltering under what is a very broad appeal, the board usually allowed you to raise your own issues as in the context of that appeal. Now it would appear that if you are being added as a party, not only must you shelter under someone's appeal, but you're effectively sheltering under issues that were already raised by the appellants, which means you're not going to be able to raise independent issues on your own. And I think that will have the effect of encouraging more people to try to become appellants rather than seeking party status at a later date. And as I indicated, I think that is a change in the way the board had previously been practicing and treating these types of party status requests. The other added rule is that Rule 804 dealing with common interest classes, where the board can take a group of individuals who are parties or participants to a matter or proceeding and basically lump them together and say, one or more of you are going to be the representative of this class. And that way we don't have to hear from 20 different people who are coming up to say the same thing. As indicated in the sub-bullets, that probably works well with residents groups and neighbors who come to the tribunal not necessarily knowing each other, but when you get there and realize they all have a similar concern, it allows the tribunal to better organize how that evidence comes in. However, what constitutes a common interest class is going to be the subject of some debate, and the LPAT is going to need to develop some case law on when and how it's going to use this new rule.
And then the final slide dealing with the Part 1 rules, just as a bit of a grab bag of rules we wanted to highlight for you. The one that Patrick mentioned earlier, that at a pre-hearing conference, LPAT members can seek to simplify the hearing by examining persons at the case management conference. And we raised the issue of, does that mean you have to have your whole team available for actually attend those kind of conferences? In the past, that's not been the case. It'll be interesting to see if that practice develops amongst the board to try to scope further by seeking admissions. And then conduct and party and costs rules that are set out on that slide are self-explanatory and just lay out what the LPAT rules will be in those regards.
The new Part 2 is where things start to get interesting because it's all brand new. As indicated previously, it only applies to certain types of appeals, and we've listed the relevant sections in this slide to tell you which, if you are appealing under which sections of the Act, you're going to be subject to Part 2. The interesting one to us, because we understand OPs and OPAs and ZBs and ZBAs, but non-decisions on draft plans of subdivisions was an interesting add because it's not subject to the same new and joint tests that the OPs and ZBs are. So it's not entirely clear why non-decisions on draft plans of subdivisions are going to be subject to the requirements of Part 2 when you're not dealing with the new and joint tests the same way you are with OPs and OPAs, but there it is. When you start a Part 2 application, there is a requirement for the submission of what's called an enhanced municipal record. So the municipal record must contain all the items that Leo had reviewed in discussing Rule 504, but it also must be organized in chronological order, have a table of contents, be separated by tabs, and be bound or being capable of being bound. There's a requirement for paper copies of the enhanced municipal record, one to the tribunal and one to be maintained by the clerk for inspection by any member of the public. And then there's also the requirement for electronic copies, one to the tribunal and then one to each person who has filed an appeal. This goes without saying, but these requirements for new records and enhanced municipal record is going to put a lot of pressure and a lot more work on the plates of municipal staff, particularly in the clerk's office, who has to put all of these materials together in order to be able to be sent via paper and electronic copy. The appeal screening process is also a new step, which is within 10 days of acknowledging receipt of an appeal, the tribunal will actually screen the appeal for what they determine to be validity. Now, validity doesn't mean that they're going to prejudge your appeal. Validity means that your appeal must have provided the necessary explanation as to whether or not the instrument satisfies or does not satisfy the new and joint tests. So it's effectively a member of the tribunal who is going to be tasked with reviewing the written submission you've made on your appeal to determine whether or not you've properly explained what is the issue under the new or joint test that you are attempting to raise. If the appeal is deemed to be valid, the notice of commencement is issued and the timeline clock starts. If it's not deemed to be valid, then it can be dismissed. And as indicated in the balance of the slide, findings of validity can be challenged by way of motion. The LPAC can initiate its own motions with respect to its jurisdiction over a particular appeal. There is an ability to challenge an indication that an appeal is not valid if there is a written motion to the LPAT within 15 days. And appeals are deemed to be dismissed if they're determined to be invalid. And I would think that a determination that your appeal is dismissed is the type of final order that might give rise to a potential for a motion for leave to appeal to the divisional court. And then all motions concerning these validity issues are to proceed in accordance with the board's normal rules on hearing motions.
And what is, again, new and significant is the requirement that within 20 days after an appeal being validated, the appellant must prepare and file with the tribunal 3 copies of an appeal record and a case synopsis, as well as serving the affected municipality. And the Rule 26.12 sets out what an appeal record shall consist of. And what we find intriguing is the ability to file an affidavit or a statement setting out the material facts associated with the application, which may include expert opinions. And that provision is one that we, at this point, don't know as to how broadly the board will interpret that rule and how permissive it will be in filing affidavits that are quite significant, numerous affidavits perhaps, as a way of getting, in essence, some new evidence before the tribunal that wouldn't be part of the public record. So that this one is one that clearly could be open for abuse and open for some early testing by the OMB as to what the scope of that provision will actually be.
Following on that, and it's part of the same rule, although it's not separately numbered, there is an ability for the appeal record to contain documentation or material that the appellant wants to rely on that was available to the municipality but doesn't form part of the record, or in the opinion the appellant should have been made available to counsel. But the interesting one is C. In the event of an appeal of a non-decision of counsel, any documents or reports which update the application that is the subject of the appeal. We had always been led to believe that these appeals were, this new process was intended to be a true appellate format, where what is going to the board is essentially what was in front of council. This rule, 2612, and I suppose it's sub C, seems to indicate that where you have a non-decision of council, as part of your appeal record to the board, you can include documents that update your application. So we asked the question, does C allow a private appellant to present a revised proposal to the LPAT that is different than what was applied for and considered by council? That's not unusual in today's, or yesterday's, I suppose, process, where you have an application that was pending in front of council, you appeal on a non-decision, and by the time you get to the board, you've got a revised proposal for the board to consider, and it considers it fresh. And our understanding is that practice was targeted for to be removed from the appellate process to ensure that what goes to the new tribunal is truly what was in front of council. But as we see here, it seems that in the event of a non-decision, you can still update your proposal and provide new reports just to the tribunal. And in some ways, it might be beneficial to not get a decision from council, so you have the freedom to be able to update your proposal as needed.
So having described what the content is, there's then some guidance as to just physically what an appeal record looks like, right down to the size of font and line spacing that is to be used. The cap is 30 pages for an appeal record. I find that fascinating for no other reason than I think one of the things you're supposed to include in your synopsis is, quote, the text of all relevant provisions of provincial policy, planning instruments, statutes, regulations, and bylaws. How many of us have seen case books that go hundreds of pages containing relevant portions of official plan policies and such? How are we ever going to include all relevant policies and still meet this 30-page rule, Patrick. I just don't see it.
My plan is to use the old schedules attached to my submission as I do in my factums,
But
which
I
tend to
don't-
be much longer than my submissions.
But it doesn't say that, though, does
it
it? It
doesn't.
says 30 pages is 30-page maximum, but I think Patrick's right. What we'll all do is take the 30 pages as being our submission cap, and then appending the documentation otherwise. But that is a rule that will likely be revised in the future to add clarity to that issue.
And speaking of clarity, I'll note that where you see text in blue, that is where there is a difference between the draft rules that were circulated by the tribunal and the new rules that Leo mentioned were circulated last week.
And then with every appeal record, of course, comes the opportunity for responding records. And you'll see there that what on this slide, what the rules are concerning limits of the record, et cetera. And again, we flag that it appears that a responding affidavit by a qualified expert will be permitted as part of a responding appeal record, which would give the opportunity for filing, in essence, new evidence that would not have been before the council in dealing with matters. Patrick, you want to deal with case management?
So in Part 2 appeals, there is a mandatory case management conference, which looks a lot like a pre-hearing conference, but there are different things and different powers that the board or the tribunal is going to be able to exercise. The point of a case management conference is to allow the tribunal member to assess what they've received in terms of the case synopsis and the records, and to provide some direction to the parties about how the appeal is going to be heard. Is it going to be in writing? Is it going to be an oral submission? Is it going to be electronic? Who's going to be doing the speaking? How will we divide up our 75 minutes and our 25 minutes? There is a 75-day notice period for a case management conference, and under Rule 2619, there is a requirement for persons who want to become participants or parties to that case management conference to 30 days in advance file a submission with the LPAT and with the municipal authority indicating the nature of their interest, how their participation will assist the tribunal, and they must also explain their position on the new or joint test. It's interesting that the rules currently require those outside parties to provide their submissions to the tribunal and to the municipal authority, but there's no direction that they also be provided to the private appellant if there is one involved. Otherwise, the case management conferences are going to proceed, I believe, very similar to pre-hearing conferences, except there will be more of an active adjudication role for the tribunal member who is assigned to your case management conference, and that those conferences will result in an order that's ultimately going to govern how your first appeal is going to proceed.
Note that the tribunal members are being equipped with a toolbox that allows for active adjudication by the tribunal member. And on this slide, we list several of the tools that are now specifically provided to the board. What's interesting are the questions we pose at the bottom of the slide, or the comments we raise as to when will these powers be utilized, when can applicants and parties seek their use, and is this really a vehicle by which one might be able to quote unquote test an opinion from a party opposite or a consultant opposite through the use of inviting the tribunal to exercise any of these powers.
So what happens if you're successful on your first appeal? The LPAT is to issue written reasons if it makes a finding that you've satisfied the new or joint test. In our opinion, that is not likely a final decision for purposes of going off to divisional court. It's simply a direction that goes back to, or direction and commentary that goes back to the municipal authority. As part of that decision, the tribunal may, but is not obliged to suggest to the municipal authority how they might resolve the issue of provincial plan conformity or consistency. The other interesting question we have is when those reasons do come down from the tribunal, would that information be presented to council in camera? It is a matter that's subject to potentially ongoing litigation, but also the first appeal has already been disposed of by the tribunal, so the question becomes, is it ongoing litigation unless there's a second appeal? So that'll be a key question for municipal authorities to answer. If the municipal authority renders a new decision or fails to make a new decision within 90 days, the appeal process under Part 1 then applies if you go back up to the tribunal. So the second appeals will look a lot more like our current OMB procedures, except our understanding is that the tribunal is going to be encouraged wherever possible to use multi-member panels on those second go-arounds. Another question that we have is if the municipal authority has not changed their decision after it's already gone up to the tribunal once, is the new tribunal member who's going to be hearing the matter going to accept the finding of the prior tribunal that there was that issue of provincial plan conformity or consistency, or do we have to start over at zero again and convince a new member that we were right?
Turning then to the concluding comments on our webinar, what to expect if you're an applicant, a municipality, or a member of the public. Turning to applicants, it's important to note that not much changes for many types of appeals. Minor variances, consents to sever, site plan, development charges, parkland, etc. All of those current processes and tests remain the same. They're just heard by a new tribunal. The tribunal will be subject to getting its decisions out, as we've noted earlier. But this answers many of the questions we've already received from people. Vis-a-vis minor variances and consents, not much changes, just continue on as you've been in the past. With respect to the OP's zonings, their amendments and non-decisions of subdivision, they're all subject to the new Part 2 test and the new Part 2 rules as set out. The appeal record is to consist of what is before council, so we'll be advising all of our clients who are applicants to ensure that all their application materials are as comprehensive and accurate as possible to ensure that a full record exists. The new tests, the new records, factum, 75-minute submissions, these all look to us like almost a Rule 1405 application or a leave to appeal application that we take to the courts, where you're provided a limited period of time to argue off of a written record. We note that we don't know how active the board will be in utilizing active adjudication powers, and we simply flag from a natural justice and fairness perspective, with the limited deputation time that most councils provide you with, 5 minutes, maybe 10 minutes, and the restrictions on appeal materials, it's really important to get your materials in, but we wonder whether natural justice is served to applicants under this process. Patrick?
With respect to municipalities, there is no direction coming out of these amendments to either the Planning Act or the LPAT Act for municipalities to change their own procedures in terms of how they hear and determine Planning Act applications. But we wonder whether or not there does need to be those types of changes in order to address issues of fairness and natural justice. For example, the Planning Act since Bill 73, which is 2016, has required that councils must explain their decisions, and often we see decisions of council indicating that based on the submissions received, this is our decision. But what happens if council is not adopting the staff recommendation? What happens if council is going in an opposite direction from the submissions they've heard from the public who've given deputations? how is it the council is providing the necessary explanation to conform with the requirements of the Planning Act? And is there a need to reformat the public hearing process that a particular municipality engages in so that they're not using up all of their council time, and council agendas are already long enough, hearing deputation after deputation after deputation in favor of a particular application? Another question is whether or not staff should be providing opinions on the new or joint test, whether circulation comments should address the new or joint test, or should the test at the municipal level remain one of good planning in accordance with the local official plan. Clerks are going to be tasked with creating new municipal records, and as we mentioned before, some of these reports and these applications can be thousands of pages long. And also the requirements or the rules regarding records of council proceedings. If your municipal council is not currently creating video or audio records of its proceedings, should it start? And also what changes to staff reporting procedures need to be made to address the 90-day window that the LPAT is going to be remitting matters back to council. We know that some municipalities, 90 days is their standard cutoff date to meet an agenda.
In order to get to some of the questions, we'll just breeze through these last two slides. It's certainly not become any easier for the public to participate in these processes, recognizing the issues that they'll face to comply with some of the rules that we set out on the slide above. And then the final slide, we just wanted to note, here's the link to the new board rules. I'm pleased to say one of our listeners is advised that the appeal forms have gone live on the TLAB website just a few minutes ago, so that's good to know. And finally, the OMB did have a website up with a webinar that it put on and some PowerPoints that it had prepared. I'm not certain if these have been lost with the transfer over to TLAB or whether they'll still be accessible, but do take a look at that. We'll now try to get to a couple of questions that we've been given. First one I see that's interesting is, are municipalities obligated to participate in case management conferences or only in cases of a non-decision?
Obviously, there's nothing that compels a municipality to participate in a case management conference if they have no interest in the matter, or if they've supported the decision and their decision's been appealed. And we see that at the current OMB, that sometimes the municipality doesn't necessarily show up to defend council's decision. So there is no obligation to show up. Certainly the board would be interested in hearing what the municipal position is, and the board is going to have the power to, if they need to, summons and cross-examine municipal staff if they want to get to the bottom of what was the municipal recommendation before council.
It might feel like cross-examination, but it's just an examination, Patrick. Another question, is a party in addressing whether the joint or new tests have been met going to rely solely on legal argument, i.e. no planning opinion at this stage? Is there scope in the appeal application to include a planner's affidavit? Or is the onus going to be on parties to specifically address the new tests? My answer is, while it's oral submissions, it's not just legal argument. It's oral submissions on the facts, oral submissions on the planning tests that have to be met. Can an affidavit be filed by an applicant's planner as part of an application? Absolutely. But normally the planning report that a planner will file will normally contain all of the opinions that the planner has on the matter, and one would assume the formality of an affidavit would not be required. But it would certainly be incumbent upon any consultant filing their staff report, their planning opinion or justification report, to include as part of that report their acknowledgement of expert duty to indicate their independence of their opinion from that of their clients.
And we do have a lot of questions about what is going to be the roles of planners and these new processes for appeal routes that aren't changing. Committee of adjustment, for example, the tests remain the same, the process remains the same, the appeal rights remain the same. There are certain, filing differences in terms of electronic and printed copy once you get to the LPAT, but all of that generally remains the same. And committee of adjustment members, their processes remain the same. For a lot of the Part 2 processes, your OPAs, your zonings, your subdivisions, decisions. There's going to be a big emphasis on front-loading the process so that when that municipal record gets compiled, it contains the most accurate and best representation of the matter you want the board to or the tribunal to rule upon. And that's where we think that consultants are going to have to huddle with their lawyers to make sure that their materials are accurate and appropriate from the get-go, because you may not get a chance to supplement them thereafter.
Final question we have time for is, do decisions under the old regime have any value or status under the new regime? Do LPAT members have recourse, guidance, or utility to historic cases and decisions? The answer is, in a word, yes. Those decisions will continue to be relevant to many matters and hopefully have persuasive value. So we'd like to thank all of our listeners today for participating. We have more than the questions than we could get to. We thank you for your interest. Based again on the demand of registrations we've had for this program, we're hopeful to be running a third one in the not-too-distant future as things unfold and issues start arising that might be of interest to our listeners. So thank you again.